for looking at the video for the New York retainer for purchasers. In my firm, you're hiring 2 attorneys, you're hiring the whole firm, myself and my partner, Jessica Villaplana. You're not hiring a specific attorney, even if you refer to one or another. We both work the files equally, and so does our staff. So please feel free to speak to any one of us about your specific questions. The good thing in dealing with a firm that you have multiple attorneys on is that if one is sick, one is on vacation, or just other things in life happen, we're able to help accommodate in most situations your closing date. You're hiring us for a specific transaction, a real estate transaction. Although we may help you with advice on other legal issues you may have, we're not going to represent you in anything that we don't have an agreement on. The most important thing when you're signing a contract is to understand that it is legally binding, meaning whatever is not in your real estate contract does not have to be honored. It doesn't matter if something was on the multiple listing service, if your agent promised it to you, your loan officer promised it to you, even if your attorney promised it to you. Ask your attorney or whoever's reviewing your contract with you, where is this item that I really care about? Where is my seller's concession, if there's one? How long does it take? How long do I have to get a loan commitment? How long do I have to close? Where does it say that I'm getting that red and green furniture that I really wanted? Please make sure you go to your contract, understand your contract, again, because once you sign it, you're bound by it, and you have to hope now that the other side that promised you something is willing to give into that promise, even though legally they don't have to. Oh, and repairs, very important. You may not do an inspection, or you may be really handy. But if you're waiving an inspection, we're your attorneys, we're gonna do what you like, but just know that then those items afterwards are not gonna be fixed. So please make sure you're aware of what you're purchasing. If you're waiving an inspection, that you're right. If you're getting an inspection, send us a list of the items that you want taken care of. We can go over your inspection report, but I can't legally tell you what you should fix or not. A repair request may kill a deal, that you really want this house, and unfortunately now the seller feels you're being too difficult, or the repair may be so important to you that you're willing to cancel this deal that you had an accepted offer for. So if there are any requests, no, all houses are sold as is, but if the seller's willing, they will give you a repair credit, or you'll get a repair agreed to. Just make sure whatever you're finally agreeing to is in the contract. I get a lot of questions on, well, what's your fee? Well, our fee's in the retainer. We charge a $350 retainer fee when we sign contracts. So we do a lot of work in the beginning for nothing. And if you don't ever sign contracts, you don't give us that retainer fee. Upon payment of that $350 when you're signing your contract, that is non-refundable for the work that we have done and the work that we're going to do. You would only owe us the balance of the payment if we close. If we don't close, you don't owe us any other money, except if you're in default, meaning, hey, Steve, Jessica, get me out of this contract, I want to buy that house. That's a default. If we're successful in doing that, we'll get your money back, but you would still owe us the balance. Now, what happens if through no fault of your own, the deal dies? Well, you don't owe us anything else, and we typically will roll over that $350 into your next deal, so you don't have to pay a retainer again. The good news is, with that payment of the $350, I provide free tax preparation for my clients the following year, so you are getting something for your money. There's never an additional charge to you, because again, we do have a flat fee, except in the situation we've outlined in your retainer. So just look at your retainer and you'll understand those, but they're very rare. Typically, it's only there's going to be post-closing escrow involvement. If there's going to be a situation where you need to close on a specific day regardless of our schedule, and we have to get coverage for you, and you're not willing to move it a day over or be somewhat flexible, and again, because you are our you've hired us, you're our boss, we're going to try to accommodate you. If there is a power of attorney, there's going to be a charge for that. Typically that's found with more sellers, not for purchasers. But if you are in a situation where you have multiple parties and one of you can't make it and your lender agrees, there's going to be a fee for us to do a power of attorney. Again, it's all listed here. Title searches. We're going to hire a title company to either provide a lien search in a co-op or for a full title search in a purchase. In a situation where you have a relationship with a title company, just let us know. We'll order from the title company that you'd like. If not, we'll go to one of our recommended vendors. Bank attorney work. In New York, sometimes your lender will want us to be your lender's attorney, and that's great. You have one less person to worry about in scheduling. The fee that they pay us, we just let you know that, yes, you're financing, so in essence, you're also paying for a fee, but the fee they pay us is the same that another attorney would be paid if they represented the bank. Again, the benefit is that you are going to get things faster and you don't have to worry about another firm schedule. Okay, these last 2 pages, they're in regards to important information that you as a purchaser should be aware of. They are not a legal contract between you and myself or you and my firm. They're things that are very important and through our time come up again and again. So number 1, be careful when you're going to lock your rate. When you lock your rate, you have to close by that date, or typically there is an expense that is charged to you from your lender. So give us a call. We will then contact the seller's attorney, make sure that, hey, seller's not in the hospital, the seller's attorney's not going away, everyone expects to close on that date, they're available, that there are no title issues, or if there are, the seller believes they're going to be rectified in time. In a title report, there are 2 parts of the title. You have the regular report and the chain of title, and you have the municipality report. The municipality report will have things like open permits, for example. We want to make sure that you're aware of these items, and if you require them to be fixed prior to closing, or your lender requires that we're going to be able to meet those deadlines. If not, you may want to rethink about locking your rate. Again, you're our boss. We're going to follow what you want. We just want you to be aware, because the seller is never required to pay for your lending institution closing costs, even if it is a locked rate situation where it is their fault. Sometimes you'll have sellers that do, but they're not legally required to. So keep that in mind. Ordering a survey. So this comes up so much. Surveys are pretty much a drawing, a map of your property. It's going to indicate your boundary lines, if there are possible additions to your land, if your neighbor is encroaching onto your land. Now, some banks don't require it, and you may want to save on the money, and that's no problem. We're going to do with what you like. However, if you need a survey or you would like a survey, those have to be paid for no matter if the deal dies or not. So I never want my clients to have to pay for something that they're not going to use. However, you may want to close and you may be willing to risk the fact of not closing versus and paying for a survey versus closing late and not having a survey in time. So just work with us. When you know you want to close by a certain date and a survey, for instance, takes anywhere from 3 to 4 weeks, just give us a call and let us know you want to order your survey. If not, we're going to wait till the lender tells us it's time to order a survey, or until when we call you, when we know everything's clear, or we believe everything's clear, and then we order the survey. Because again, surveys can range in prices from anywhere from $750 to $1,000 in New York City to sometimes up to $2,000 upstate. I had a client once that asked, is your purchase contingent on your sale? The client said no, but did not let me know that they were not aware of what that meant. If your attorney's asking you something is contingent on something else, pay attention to what he's asking you or she's asking you, because that's a very important factor of the deal. You are typically in default of your contract and will lose your down payment if you have to sell another property in order to purchase this one, and that property that you have to sell ends up not going through. So if you need to sell a property or refinance another property, make sure that your contract is contingent on that. Default. What's the biggest reason for clients losing their down payment? Well, I always say, don't go out and buy a Ferrari when you're purchasing a home. Some people will trade in a Honda Accord lease and get the BMW truck of their dreams in the middle of a purchase. Don't do that. You have specific debt to income ratios. If you're denied because after signing your contract and applying for a loan, you change your debt to income ratios and no longer are approved, that is a problem. Family. I love my family and I'm pretty sure you love yours. Don't lend money to family when you're in a purchase transaction. I've had situations where people have passed away and the family had no insurance and they needed to get money for a funeral. The problem is the money that you get back may not be able to be used for your closing, and you could be held in default if your bank denies you for that purpose. So anything financially, big deposits, large withdrawals, opening up a credit card, shopping for anything, please speak to your lender about those things. You want to make sure that this money is good. It's been in the bank typically 2 months. So don't withdraw funds, make large deposits, apply for credit cards, apply for new debt until you've spoken to your lender. Make sure that they okay it, because at the end of the day, it's your down payment we're talking about. Your closing date. In New York, there typically is an on or about closing date. Now, if your contract says time of the essence or some different variation, speak to us about it. And those are usually firm dates. Firm dates are very rare in New York. Usually everything is on or about. Typically, industry-wide, that's within a 30-day period. So if you have an on or about of 60 days to close, that's about 60 to 90 days to close. That means you can close within a 30-day period to a 90-day period. And the same goes for the seller. So just keep that in mind. Just because you're ready to close, that doesn't mean the seller's ready to close. If you decide to close with any open issues, open permits, things of that nature, we're gonna do as you ask, but we're gonna ask you to sign a hold harmless agreement, that you're aware that we are warning you the ramifications that are involved in closing with these open issues, and the solution that we were able to provide, whether it be hold money escrow, or if there is no solution and this is what you're choosing to do, you're just gonna sign that document for us that you're aware of that. Closing times. Closing times for us are typically set when the bank gives a clear to close, we contact the seller when they're available, and we find out when you're available. All parties have to agree, so just because you have a clear to close from your lender, it doesn't mean we're closing the next day. If you have a co-op, well, after your board approval, your lender has to give you clear to close, and then the co-op attorney, they're the ultimate entity that determines what availability we have for closing. And then everyone has to work around that schedule, so keep that in mind as well. Also with co-ops, there is a thing called a recognition agreement or an Aztec agreement. Those have to be sent to the board for signature before we close. With co-ops, I want to just point this out. They're a little unique in New York. You have typically 10 business days to submit your board application if you're buying all cash, or 3 to 5 business days if you're getting a loan from the issuance of a loan commitment. So just keep that in mind. I've never had a client been in default for that. I always stress that point, but you don't want to miss the dates. I typically tell my clients, have your application ready so that the minute you get your loan commitment, you can just supply it to the board. There are occasions in certain, especially with HDFC co-ops, and I can speak to you about that, where the board actually reviews your ability to live in that community prior to contract, but they're rare. So just keep that in mind. In addition, a co-op attorney is the one who kind of dictates when we can close, even if you have board approval and you have a clear to close. The co-op attorney will not set the date, typically unless they have your Aztec agreements or recognition agreements signed. So the minute you get those in the mail, please sign them, submit them to the board, and give proof of who you gave them to at management if you FedExed it, great. Just keep a receipt of the delivery. Lastly, last two things. If there's tenants in the home, let me know and try to let me know at contract signing so that we can make sure that the agreements are right in your contract. And ultimately, no matter what legal rights you have in the contract, we as attorneys can't enforce that right without going to court. So we can email, we can tell you you're in the right, but when it comes down to anything, if there's a disagreement, only a judge can solve a dispute. So again, if there's any questions you have in this, let me know and I'll be happy to answer. Hope you're enjoying the videos that you've watched today. They're not meant to be a substitution for speaking with your legal professional, but just an educational tool. Thank you.